in the Q&A box. And if you have any difficulties, please just reach out to us through the chat. But thank you very much for joining us and welcome.
Pleasure.
Thank you, Julia. So as Julia said tonight, our guest speaker is the Honourable Marilyn Warren, ACQC, former Chief Justice of the Supreme Court of Victoria. She was the first female Chief Justice in any Australian state or territory and was a Supreme Court judge for nearly 20 years. She heard cases in presiding over cases in all of the courts list with a particular focus on commercial law, and was the judge in charge of the commercial list for many years. Aside from her judicial career, Her Honour has held a wide variety of positions, including Lieutenant Governor of Victoria, President of the Victoria Law Foundation, and Chair of the Judicial College of Victoria, and many other esteemed bodies. She's currently the Vice Chancellor's Professorial Fellow at Monash University and the Judge in Residence at the Law School of the University of Melbourne. We're very lucky to have her joining us tonight. And we understand it is a very odd time, but the time difference with Australia is extreme. So we're grateful for you for tuning in. And for those of you who couldn't come at this hour, the webinar is being recorded, so it will be available later on. So the format for tonight will be Her Honour will speak first about charities law and explain looking at natural disaster fundraising and the role of collectors such as PayPal. She'll be looking at an international focus on the differences between different jurisdictions and how they handle disaster fundraising. And then there'll be a bit of an opportunity for Q&A. So please do pop questions in the chat, hopefully about this topic, but if you do have questions generally about life at the bar or Her Honour's career, I'm sure she'd be willing to answer some of those as well at the end. And we really hope you enjoy. Thank you very much for taking the time to be with us tonight.
Well, thank you very much, Mia and Julie, for that very, very warm welcome. And good evening, everyone. It's morning for me. Despite what Mia has said, it's not inconvenient. It's a little after 8 a.m, so my day is just beginning. It's wonderful to be with you, and I really look forward to our conversation today about charities law and in particular modern fundraising in the context of major crises. What I'd like to do initially is a little bit of scene setting and go back to the Australian summer of 2019-2020, which for most of you would be your winter. But that summer, we saw in Australia catastrophic bushfires along the east coast and southeast coast of Australia. At one point, as an Australian citizen, it was as if the eastern side of the country was wholly ablaze. There were fires on King Island off South Australia. Earlier, there had been fires in Western Australia. We had fires raging along the Gippsland East Coast area of Victoria. And then there were fires that jumped the border into New South Wales. At one point, there were even some fires up near the border with New South Wales, Queensland. The fires started particularly in the month of November 2019, and they continued right over until about February 2020 before they were actually brought totally under control. So we had this time of immense crisis where 33 lives were lost, well over 1 million hectares of land was burnt. It's estimated that over 1 million wildlife, think kangaroos, koalas, potoroos, wallabies, all of those unique Australian animals and wildlife were destroyed or injured. And the big difference with this particular crisis was its timing, occurring as it did at that Christmas New Year period. The fact that in the Northern Hemisphere, as well as in our own hemisphere, it was a quieter time in terms of news time. Invariably, what happens at that time is that journalists go on leave. Well, what happened in this situation? The fires were so serious, so grave, and there was a very difficult problem with communication and ensuring people's safety, the Australian Broadcasting Commission came to the fore in a way that was just extraordinarily courageous. The ABC, because of its national base, has reporters in most major regional centres as well as the capital cities. It also has extensive international networks with journalists all around the world. The ABC started reporting with people on the ground. Camera people were going out and they were right behind the firefighters fighting the most dreadful, dangerous situation. The journalists, some of whom were international journalists such as Phil Williams, who is ordinarily now at the Washington desk of the ABC, were there with the firefighters with their large yellow fire protection coats and helmets out there in the fires giving direct feed. That feed was being picked up and broadcast all across the country and indeed all around the world. For those of us in Australia who had family swept up in the fires, those family often found their communications closed down and they did not know what was happening. Some, such as my own family members, were forced to evacuate their country residence with their dogs and horses and go to a coastal inlet. They did not know what was going on. They did not know how safe they were or how unsafe. At one point on New Year's Eve, the sky turned black at 3 o'clock in the afternoon, and it was as if it was night. The air was dense with ash, and people were truly, truly fearful for their lives. At one point with some of these country towns, in particular the one where my family was located, the firefighters retreated with their fire trucks to the town and formed a perimeter circle around the town, ready to fight the fires if there was not a wind change overnight. All of this terrifying, terrifying footage and information was being broadcast. It was being picked up by CNN, BBC, Al Jazeera. What it led to was something that was, in my experience, unprecedented generosity by the Australian nation and indeed the whole world. I've pondered why that was so. I think it can be attributed to the timing of these fires, the extended period over which they played out, and also the significant role of the Australian Broadcasting Commission in feeding all of the information out to the country and the world. If we compare the experience with, say, the Japan tsunami or the Southeast Asian tsunami a few years ago, or even the pandemic experience over 2020, the coverage of the Australian bushfires over the summer of 2019-20 was unique. I just want to give you now a last little piece to provide a setting of the scene. An ABC journalist, Phil Williams, I mentioned before, an international journalist, described an interview with a resident of a town in New South Wales which had been destroyed by the bushfires. Phil Williams wrote, "She says," the resident he's speaking to, "the emergency call operator spoke in a calm, clear voice. He was so nice, but he just said, 'Try and get a wet towel.' And I said, 'Well, we are dying.' And he just said, 'Well, you're on your own.'" The journalist went on in another description about another person affected by the fire. He described her this way: "Her house is gone, sheds and stables too. The awful shock sets in and the tears begin to flow. She says, 'I can't believe it. I just can't believe it. I don't know what we're supposed to do next. I just don't know. I think we've just got to get on with it, hey? It's going to be hard, but we have to do it. I'm not going anywhere. I'll rebuild again. Now, that kind of communication, as I said, was being beamed all around the world. Into the fray of all of this comes one Celeste Barber. I did not know Miss Barber before that summer, but you younger ones probably did and do. I understand that she is a comedian, humorist, specialising in stand-up comedy, as it's called, and online. She was an Australian and she was living in the United States. She commenced an appeal off her own volition, and it led to an outcome that was truly quite extraordinary. On the 3rd of January 2020, Celeste Barber started a fundraising campaign on Facebook. Now, if you went to the website, you would see a photo on the Facebook page showing a building engulfed in a wall of flames 10 metres high. Then there is a figure of what looks like a firefighter in uniform in front of the flames. Now, remember, all of this is occurring in that context I described a few moments ago. Now, under the photo was a caption, and there was a statement by Miss Barber. She said, "Please help any way you can. This is terrifying." In much smaller font, there was another statement: "Fundraiser for the trustee for New South Wales Rural Fire Service and Brigades donations." There is then a picture of Miss Barber and a statement: "Want to join me in supporting a good cause? I'm raising money for the trustee for the New South Wales Rural Fire Service, Brigades and Donations Fund, and your contribution will make an impact, whether you donate a lot or a little. Anything helps. Thank you for your support." Then what Ms. Barber did, she spread the message quite a bit. She spoke about funding being necessary to save lives, help people generally, support firefighters and the fire service, and help wildlife. Remembering all of this is going out all around the world. There was footage of kangaroos hopping across walls of flame, badly burned kangaroos being rescued at the base of eucalypt trees. There was a great outpouring. People saw the women I referred to in the interviews by Mr. Williams, who'd lost everything. They were sitting in the embers of their home, still smouldering. There were farmers breaking down on television, crying over the fact that they had had to shoot all their livestock, their horses, their dogs, everything they had. This kind of poignant tragedy penetrated the heart of citizens, and it was that very sentiment and emotion upon which Miss Barber focused, and because of which she was extremely successful. She raised $51 million Australian. Throughout our conversation, when I refer to dollars, I will be referring to Australian dollars. Now, I just want to go back to what the online funding message and presentation was to the donors. Going to that Facebook page, when one scrolled down, there was a heading of the fund, a statement that it was a registered charitable organisation, a note as to where the fund was based, and a line reciting community and economic development, presumably a reference to the Fire Service Fund's purpose. Then there was this statement: "Donations will be granted to the charity by PayPal Giving Fund within 15 to 90 days. There is then a learn more click, and at the end, again, a smiling face of Miss Barber appears. So there we have it, that with this collection of funding, there is an intermediary, PayPal. I referred earlier to other international disasters. When those crises occurred, there was not the internet social media capacity that there is now. Hence, this was a major catastrophe that was able to take advantage and benefit of the internet and social media through the intervention of the intermediary. Now, before we talk about the actual case that ended up in the Supreme Court, I'll just give you a little outline about some of the things that were contained in the website. The role of the intermediary was very important. Barber set up the fundraiser and it went viral. But what was not clear to most, or indeed other than the most discerning donor, was that the donor was not giving directly to the charity itself. The donor was in fact making a gift to the PayPal Australian Giving Fund, a charitable fund, and then it was PayPal that was making the donation and distribution to the charity, the Royal Fire Service. Now, when making a donation, if you think about it, you don't give to PayPal or an intermediary. You as an earnest and well-meaning citizen, give the money to the charity, whether it's for the benefit of the bushfire circumstances, some other natural disaster, for a children's hospital, and so on. Now, when you made a donation on Facebook, you needed, with Ms. Barber's case, to make the decision, and then you had to click onto payment. So there are then terms and conditions, but human nature being what it is, donors by and large, I suspect, did not pay attention to those terms and conditions. Then as well on the Facebook page, there were terms of service that flashed up to the effect that PayPal would make every effort to ensure that the monies reach the particular charity. The terms of service are not easy to find. Now, if you visualise some individual at home with their family who is not a lawyer, not an accountant, but they have a very humane desire and generous desire to contribute and help those, or perhaps support Australian wildlife, clicking on terms and conditions and terms of service would be the furthest thing from the individual's mind. And the question then will be raised about the particular case involving Ms. Barber is whether the expectations of the donors were in fact met. Bear in mind also the reference in the Facebook page that the fund PayPal would pay the charity within 90 days. Under all of those various clicks, terms of service and so on, there's also an FAQ section, and then there are pop-up boxes, and you can trail things, and if you want to really probe it, you can find out more things. But there is a question, when PayPal played this role as an intermediary, was it proffering an undertaking to the donor? Was it entering into a contractual obligation? What precisely was its role? It is quite unclear, and unfortunately, as I will discuss shortly, it was not considered in the Supreme Court case. Once the monies are passed across by the donor, the click is made, it creates what the judge in the New South Wales Supreme Court described as a click contract. PayPal has exclusive legal control, and it is up to PayPal to determine to whom, when and how the monies are distributed. All of this state of affairs was quite unsatisfactory. Meanwhile, individuals continued to pay substantial amounts of money, up to, in the end, $51 million. I don't know if any of you are music fans, but perhaps it could be said that the fundraising by Ms. Barber reached its crescendo in February, when there was a very significant all day into the evening rock concert. And all the leading Australian and international performers came along and donated their services for free. In between each performance, Miss Barber would come forward, and this was conducted in a very large stadium in Sydney with over 100,000 present. It was streamed live to Australia and I believe streamed overseas. Money was pouring in. Miss Barber continued to talk about supporting the fireys, as she called them, the firefighters. There was constant footage in between performances, including footage of the wildlife. It was not made, in my view, clear at that concert that the donations would only go to the New South Wales Fire Service. The crescendo, or the culmination of this rock concert, was a performance by the reconstituted rock group Queen. Now, some of you may have seen that fantastic film Bohemian Rhapsody. If you haven't seen it and you like rock music, it's a great piece chronicling modern music, rock history. But what is portrayed in that film is the last 20 minutes of a bracket or performance that Queen gave at the Band-Aid concert about 30 years earlier, with Freddie Mercury at the height of his performing powers. Sadly, Mr. Mercury is no longer alive, and the band has reconstituted with a new lead singer. For the first time since its reconstitution, the band played the same set as it played at the Band-Aid concert with Freddie Mercury decades earlier. Well, how can I put it? The place went right off. It was, I've got to say, very exciting, a very vibrant performance. And of course, the money poured in. Now, Queen were providing their services and encouraging generosity by the audience, both the physical audience and the viewing audience. All of this happened and the money was coming in. Moving on, the fires eventually were placed under control, and the trustees of the Royal Fire Service Trust Fund had this substantial amount of money, but they were faced with the expectation of donors that the monies would be expended beyond the Royal Fire Service of New South Wales, spent on injured and damaged property, wildlife, persons who had lost their home, the families of firefighters who their loved one had been killed in the fires, and also that firefighters beyond the borders of New South Wales and other individuals would benefit from the fund raised by Ms. Barber. By that stage, PayPal had transferred the full fund and closed it off. It had transferred the full fund to the Royal Fire Service without any consultation or inquiry of the donors. Bear in mind that because of the payments being made online, there was a capacity for PayPal to contact donors or through some other medium inquire as to how individuals wanted the money spent. But without consideration of donors' intentions and expectations, PayPal transferred the money across to the Royal Fire Service Trust Fund. Later, after all this occurred, there were some surveys conducted as to the expectations of donors, and the expectations were quite broad. There was a desire by donors to contribute to communities broadly impacted by the fires, also firefighters, and also that they wanted to provide food and resources to families who had lost everything in the fires, and also that they wanted to help wildlife. There was, in fact, coming out of this survey, no unified purpose that could be identified. Hence, at this point, the trustees of the fire service faced the difficulty, what did they do with these funds? And as a result, they exercised their right as trustees under the New South Wales Trustee Act to go to the Supreme Court, ask a question of the court under section 63 of that act as to how the trustees could expend the money. There were three specific questions asked of the court. First, whether the trustees could expend the funds on charities, persons and firefighters beyond the Royal Fire Service of New South Wales, to which the court ultimately answered no. The second question was whether the monies could be expended on the families of firefighters who had been injured or killed from New South Wales in the fires, and the court answered yes. The third question was whether the funds could be expended to the benefit of firefighters by providing training and education and facilities about fighting bushfires in New South Wales, to which the court ultimately said yes. In proceedings like this, where the judge, the court is asked to provide an advice to trustees, the benefit to the trustee is where there is doubt, then there is clarification by the court. It is binding, and in effect, the trustees are protected by the fact that they act on the basis of the court's advice. In this kind of litigation, there are intended to be both a protagonist and an antagonist in a sense, in the adversarial sense, but it's not truly adversarial proceedings. It is in fact more, at most, I'd say, inquisitorial. In these types of proceedings, it is traditional for the Attorney General of the jurisdiction to come to the court exercising what's called the parens patriae function, the protection, in this instance, of the charities, and to provide, play a neutral role in the court, a type of counsel assisting role in some respects, but also explaining to the court the facts of the circumstances, stating the law, and submitting to the court a particular course that the court may adopt. The proceedings in the Barber case, in my view, were disappointing. Essentially, His Honour Justice Slattery of the Supreme Court of New South Wales was constrained by the way the case was presented to him. In my view, His Honour would have been assisted if there had been a full contradictor. What happened here is that PayPal and Celeste Barber played a passive role the main role of agitation or advocacy was left to the Attorney General. I see in modern terms some potential difficulty in that. The Attorney General of a state is a minister in a cabinet, and the government of a state has an annual budget, and part of the annual budget of a state will necessarily include, in Australia, its firefighting service. There could be an argument that there is a perception of bias, not actual, but perceived bias, on the part of a minister, here an Attorney General, who argues for a particular position that benefits the state. And in one sense, the donation by the fund associated with Ms. Barber has led to donors all around the world and across Australia contributing to the benefit of and the budget of the New South Wales government, albeit that the best intentions were to benefit the firefighting services, individuals affected and wildlife and so on. The particular case was decided quite narrowly in the Supreme Court. There was very limited evidence, and there was, I wondered why there wasn't footage shown to the judge of the way the funds had been collected online, and also the collection of the funds through the benefit of the fundraising concert. All of this was not considered in the court, and in my view it ought to have been, to ensure the court was fully apprised of the intention of the donors. There was one other important aspect of this case which I found disappointing, and it's that on one view, some donors, made the donation to PayPal in the expectation that their donation would benefit people in Victoria, for argument's sake. Well, that's not going to happen now. And what we do face, Australia is a federation, is that the New South Wales firefighting service will have fire trucks and the like that they can take up to the border with New South Wales of a considerably higher, perhaps Rolls-Royce standard, compared with what the firefighters on the other side of the border in Victoria have, because of the way the funds ended up being distributed through Celeste Barber's fund. This question of the donor's intention not being fulfilled, in my view, gave rise to an argument about mistake. This was a contractual context. It was a click contract, as His Honour said. But the whole topic of mistake and mistake in the context of contract was never considered. Hence, just to sum up very quickly about the Barber case, the sorts of things as a judge I would like to have seen would have been directions, hearings, consideration of the evidence of Miss Barber, the evidence of advertising and of the benefit concert. I would have inquired about evidence as to the intention of donors, and I would have also expected a contradictor to have been in court arguing a contrary view. I did touch a moment ago on the role of the Attorney General. The role of the Attorney General in this sort of situation is quite significant. The Attorney General is not just another party. He or she is seen as playing a neutral role and assisting the court in every way possible. So I think for the purposes of our discussion, we can ask a few questions. Natural disasters through climate change are causing disruption to the conventional way of doing things, that is fundraising. And we can see that gifting patterns have changed in response to these crises. How are they in fact to be managed? Should there be more appropriate consumer protection with crowdfunding for a crisis? Should there be charity accountability? And what should government regulation look like in these circumstances? If we bear in mind that with the Barber situation, money was being collected not only across Australia, but from all around the world, there are different charity regulations around the world. So, for example, Britain has the Charities Act of 2011, I think it is, and the sections in that act and the way the Charities Commission under it run, there's quite strong regulation of fundraising. The European Union has quite strict standards. Australia does have a Charities Commission, but to some extent its role is undermined by what happens at a state level. So there is this question when there is funding being raised internationally as to how international controls are exercised. We can only anticipate that there will be more and more of this. I did want to mention to you that the PayPal role, acting as the intermediary in the Celeste Barber case, I would suggest proved quite unsatisfactory. That's to be contrasted with what has occurred in the United States. In the United States, the New York Attorney General conducted an investigation into PayPal for similar circumstances to the sort of thing that arose here in Australia, that is where donors made a donation through the intermediary of PayPal, but the charity ended up applying those funds for a purpose that did not reach the expectation of the donor. Several states in the US joined in with the New York Attorney General, and ultimately there was a very full investigation which led to PayPal agreeing to the following: to make prominent disclosures to donors that they are making donations to PayPal and not the charity they select. Secondly, PayPal agreed to note the use of language implying that potential donors are directly donating to their chosen charity. And thirdly, PayPal undertook to make prominent disclosures about fees charged by PayPal, because of course when people paid through their credit card or their other banking facility, there was a fee being charged. PayPal also undertook to notify donors when it exercised its discretion at variance with what the donor intended and redirected the fund. PayPal also agreed to pay a fund of money, not very much, but still a fund of money to the National Association of Attorneys General Charities Enforcement and Training Fund. So the US has taken a stronger approach, which we're yet to see elsewhere, and I'm particularly mindful of the deficiencies in Australia. The last observation I'd make about the PayPal and Barber case is that there seems to have been, in these circumstances, an absence of any consumer protection. In Australia, we have the Australian Competition and Consumer Commission, and in each of the states there is an Office of Consumer Affairs, separate and independent of the ACCC. Both sets of bodies have functions to protect consumers. It is, in my view, disappointing that a strong role was not taken by those bodies to protect the donors in these circumstances. And it is to be hoped that perhaps after the experience with the Barber case, that they may in fact monitor the activities of intermediaries such as PayPal. So they are my remarks. I haven't talked about the history of charities. So if I can give you a very potted version, the whole concept of charitable support grew out of the feudal ages and the what was seen as a moral and religious obligation to protect the aged and the infirm. Later, during the Reformation period, it moved out of the religious area, and so we saw the statute of charitable, the Elizabethan statute of charitable uses, which brought to the fore the concept of public purpose. Into the 20th century, we saw a number of significant English cases, such as Pemsell's case and other cases, where public purpose came to the fore. And what I would suggest then, in the late 20th and into the 21st century, we've lost our way a bit with charities law, because the focus has been on charities through the prism of taxation law, rather than what I will call pure charities law. And it may be that for that reason, we've lost some direction and underappreciated the need for more acute consumer protection of charities under charities law. However, as I said before, it varies across jurisdictions. The United States has a strong position, as shown by the PayPal case. The UK position through the Commission is strong, but otherwise it varies around the globe. So there's some observations about what was a very topical case, and there was a lot more to it than what Queen sang during the fundraising benefit concert, We Will Rock You. So over to you, Mia.
Thank you, Marilyn. That was fantastic. I've definitely learned a lot. I have a question. I'm trying to work out how to put it eloquently. I'm interested in this shift that you've discussed from charities law being something that seemed quite religious and moral, and now it seems like more of a commercial transaction between the donor and the person taking the payment. I know that seems like a consumer transaction to me when I see it pop up on my social media feed saying donate to my GoFundMe, the same way there might be an ad to buy a pair of jeans. And I'm wondering if it's become more of a consumer sort of activity, is there a way to regulate it like we regulate consumer transactions? So we have like consumer contracting protections and things like that. Is there anything similar for consumers who donate to charity to sort of enforce where their money goes, or are they completely at the behest of who they donate to?
Well, as the Barber case demonstrates, if an intermediary is involved, and it seems that by and large charities are using intermediaries because of its convenience. They don't have to be concerned about receiving the funds and banking it. All they do is wait till the end of the fundraising campaign and they bank a cheque. There is, in my view, a need for a very deep and wide review of what happens in the circumstances of these natural disasters. And because it's international, it would be, in my view, highly desirable for there to be a cooperative study and investigation that is transnational. There's quite a bit of academic work being done in Australia, and I would encourage all of your colleagues. This is a new growth area, the merging, or I would say a merger, of charities law with consumer law. And the things that could be done but won't be done unless a regulator intervenes is for the likes of PayPal and other intermediaries to provide proper consumer information on their Facebook or whatever the other social media platform they use. It can't just be a case of a click contract and click terms and conditions. It's most unsatisfactory. So perhaps for some of your colleagues, there's a PhD thesis or some other doctoral thesis sitting there waiting to be done.
There you go. Someone attending tonight's got the scoop on a PhD topic. So that's very helpful. Just to kind of close that out, there's no way of bringing some sort of action for saying that they entered into a click contract based on fraud or misrepresentation, is there, for the donor?
Well, arguably there is, and quite significantly in the New South Wales Supreme Court judgment, it was left open that a donor could resort to proceedings as to the way in which the donation was spent or allocated. It's very interesting that the judge specifically said that in the judgment. At this stage, no one has taken it up. And I suppose it sounds terrible to say in one sense, but life moves on. So here in Australia, we experienced those catastrophic bushfires, but then only less than a month later, we were facing the pandemic of COVID-19. And I think because of COVID-19, the focus and momentum has drifted. So I would like to see it come back. I would mention we do have a tragic history in Australia of bushfires. Every 10 or 20 years, we have disastrous bushfires. So back in 2009, we had the fires now called Black Saturday in Victoria, where 173 people died. There was very significant fundraising then, but of course it was done through a different vehicle. But it took the trustees of that fund 7 years to distribute all the money. And there were complaints at the time as to the money was spent too slowly, didn't go in the right direction. The time must come when governments take a leadership role, because one important point here is that to some extent, governments have vacated the social welfare function, and they have left it themselves to intermediaries to implement the service. It's quite convenient for governments to do that. So we see that, for example, in all sorts of areas. But I would like to see regulation done. It's not that hard.
On that government topic, you've mentioned that part of the issue here might be that the New South Wales Fire Service have much better facilities now than the other states. Do you think this model of states looking after their own emergency services is potentially under pressure now, or a bit outdated, as we're seeing the scale of emergencies calling for a lot more cross-border protection? Well, we had a Royal Commission to consider the 2019-20 fires and how things could be done differently and better. That report delivered a number of recommendations to the federal government. We have a very strong federation in Australia, as the Australians in the audience will appreciate. And sometimes states are very parochial. And then there's a question of the constitutional power of the Commonwealth to intervene. On one view, you would have thought that the catastrophes of the 2019-20 bushfires
would have provided the impetus for a cooperative arrangement. We had the situation that summer where the New South Wales firefighters had different radio communications systems with those of the Victorian firefighters. The fires don't appreciate state borders, but the firefighters on either side of the border couldn't communicate with each other because they had different systems. It has been recommended by the Royal Commission, I mentioned, that change, but we're yet to see. We're yet to see. But of course, New South Wales will be in a better financial position.
We have a question in the Q&A, so I'm going to read that one out. There seems to be a reluctance of large financial institutions generally to adhere to any kind of onerous regulation, or at least they offer superficial attempts to comply, as there's very weak enforcement due to the sheer power of these institutions and inadequacies of penalties generally. Take the HSBC deferred prosecution agreement in the US following their admittance of money laundering. How do you encourage more effective international regulation of large financial institutions where we have state sovereignty, but international institutions who evade state penalties?
Well, we need to look at the prospect of trans-border penalties. This can be done through treaties where there's cooperative arrangements in place. It can be done through some of the international courts if the relevant countries are signatories to those courts. There can be difficulties with the United States because it's not a signatory to some of those courts. There are different ways and means. Public shaming, I think, is a very good mechanism. We had another Royal Commission. We've had a lot of them lately in Australia, but we had a Royal Commission into banking and financial institutions. In that case, there was very direct and confronting public shaming of the chairs of boards and the chief executive officers of major banking institutions and financial institutions in Australia. That is important. It was very, very public and communicated to the community. It had dramatic impact on one investment company called AMP, where it lost patronage and support from investors quite dramatically. We have other things that happen through public shaming. Recently, there's been a lot of controversy in Australia about the conduct of Rio Tinto, which is a mining company based in London, but it conducts major mining operations in Australia, particularly Western Australia. And the Yunkin Gorge area, where there is a considerable iron ore deposit, recently Rio Tinto exploded Indigenous caves, which were said by the local Indigenous people to have artefacts and the like that were more than 46,000 years old. And the company was aware of that, had been asked to stop. Its activities became very controversial, and it's been the subject of not just national but international outcry and acrimony. I think that is important. It's in Australia led to individuals, particularly the major investment agencies such as superannuation companies, withdrawing and not investing in companies that behave in that kind of manner, just as they do not invest in, for argument's sake, tobacco companies or companies that have been involved in asbestos mining and the like. So there are ways of working around regulation can only go so far. I mean, we only have to look at what happened with the Lehman Brothers in financial history and how during the era of President Trump and his administration, so many of the corporations laws were undone.
Thank you very much. That is really insightful, and I think has bridged a lot of gaps between sort of, I've been studying corporate law and we've been learning a lot about the effect of shaming as a mechanism for generating corporate compliance in the UK. So I think that does make a lot of sense. And it seems like one of these situations where practice has we have to learn from what's happened and things have to catch up quite quickly, which seems to be the mood of the international experience of the last year, is catching up quite quickly to a lot of change. I am aware that we're running to the end of the hour. So I guess if they wanted to ask if there's anything else you wanted to add.
Well, if any of your colleagues have a question they'd like me to answer, by all means, send it to me and I'll do my best to answer by email. I did provide a suggested reading list. So if we could have that come up on screen, I'll just run through it.
Have you got that one?
Yes, I have. So if anyone wants to look into this area more, I'll just run through quickly. The Law of Charity, Del Pont, that's an Australian publication. Professor Del Pont has provided a very good overview of the whole topic. Charity and Law, Past, Present and Future, Professor Harding from the University of Melbourne. That's a very good setting out of the history of charities law and where the crossroads that we're at now. He's also written a very good text that's about to be published on public benefit. If anyone wants to know about the role of the Attorney General, Dr. Chan has written a very good piece in the Canadian Bar Review about a decade ago. The websites are excellent. The various Charities Law Association of Australia and New Zealand has a lot there. Then there's the Australian Charities Commission website, the European website, and the English Charities Commission website. If you really want to see some enforcement in place, the charity inquiry by the UK Charities Commission into the Royal National Institute of the Blind, a very intense investigation was conducted there about mismanagement and negligence. We didn't have time to talk about taxation, but Professor Anne O'Connell from the University of Melbourne has written a fascinating text about taxation of charities and not-for-profits and how, in fact, that status is achieved, but then often these institutions go off and become extremely profitable. And the fact remains that we do not know as taxpayers how much tax we are missing out on. So that's a very interesting text. And lastly, it's a non-legal text. Black Summer is a collection of articles, very well written with photographs by Australian journalists about their experience of the catastrophe that I described. So that's the reading list if anyone wishes to pursue it. And what I would say to everyone, it used to be that charities law was regarded as very old world and very dull and dry. I would suggest, because of the modern era and what is happening and the dependence on charitable donations, it is a growth jurisdiction and one in which I hope many of you will have an interest.
Thank you so much for your time this morning for you and tonight for us. That was really, really interesting, and I've definitely learned a lot. And I'm looking forward to figuring out in my head how I think we should move forward. Hopefully talking to some people here, and hopefully someone decides to write a PhD so we can get some more answers. But thank you very much for your time, and we'll be circulating that reading list along